Hello and welcome everybody to this particularly important training webinar where we are absolutely delighted to welcome David Cox, who is going to explain to us the Tenant Fee Act. Now it's the Tenant Fee Act 2019 and any other important issues that's relevant to letting agent regulation. So welcome, David.
Thank you very much, Tessa. Good morning. Thank you for having me and welcome everybody else listening on the webinar.
How we're going to do it is David's got a PowerPoint he's going to go through. If you have any questions on the PowerPoint, can you please put them in the questions box that you will find in the GoToWebinar panel, and then when David has finished his slide I will then ask him the questions and then we will move on to the next slide, and then if there are any other questions at the end David will answer them at that stage. I'm sure you've got a huge amount of questions because this is a really important act, both for landlords and for letting agents. So I will move the PowerPoint on and take it away, David.
Excellent. Ladies and gentlemen, again, good morning. Tessa, should we move on to sort of the next slide? Yep, there we go. So what I'm going to do is, and this first slide very much talks about what is and what isn't allowed. We'll then go and look at some of the things in slightly more detail. So if we take this first slide of the tenant, that should say the Tenant Fees Act, I have just noticed. Whoops, excuse the typo. But yeah, what is and what isn't allowed. Now, probably the best way of explaining the Tenant Fees Act is that everything is banned to both, you can't charge a tenant anything. Everything is a prohibited payment unless it is specifically a permitted payment. So some of the things that have most definitely gone are admin fees, application fees, setup fees, referencing fees, contract negotiation fees, inventories, check-ins, check-outs, renewals, Saturday move-ins that I've heard some agents charge. All of those fees are going to be unlawful now. They will be prohibited payments. This also isn't something that just affects letting agents. We talk about the letting fees ban. It is in fact, as Tessa has already said, the Tenant Fees Act, so it applies to landlords as well. Research that the government have done, and that's been supported by research that we've done as well, landlords charge on average about £25 for referencing and things like that to tenants. So for the landlords on the line, you're not going to be able to charge sort of referencing fees either. It's not just letting agents that are banned, it is landlords as well. Similarly, you're not going to be able to get third parties to charge. So for example, go and get a reference from this referencing agency. The referencing agency will not be able to charge a fee either. So third parties are covered by the ban, so letting agents, landlords and third parties. The next one, no higher rent in month one. Now that's come from Scotland. So where they banned fees in Scotland, what they didn't stop was agents saying, well, you know, the rent in month one is £800 and the rent in month two and beyond is £600. They have banned that in England, so you won't be able to charge a higher rent in month one or any other period. I have had people say, well, what if we charge it in month two or month four? No, you won't be able to charge a higher rent in any one period of the tenancy than in any other period of tenancy. So you won't be able to charge a high rent in month one. Finally, you won't be able to charge a reference for a former tenant. So when tenants leave your properties, leave your agencies, a lot of landlords, most agents charge a referencing fee to the tenant to provide the reference to their new landlord, their new letting agent. You won't be able to charge the tenant for that any longer. However, what I would say on this one is there's nothing stopping you charging the incoming landlord. There's nothing stopping you charging the incoming letting agent. And I think this is something that the industry as a whole is going to make a decision come the 1st of June when it comes into force of either everybody is going to start charging each other or nobody is. Because it won't work if some charge and some don't. I would probably suggest the admin and the paperwork involved in charging each other for referencing is probably going to outweigh the actual money that you will get back, but it's up to the industry to decide. So that's what they've definitely got. What is allowed? What are permitted payments? So the first one, and I think this one really goes to show it's everything unless it is permitted. So technically, the rent on the property would be a prohibited payment unless it has been made specifically permitted. So rent and utilities, so gas, electricity, water, council tax, broadband, TV license, obviously all acceptable. But I think that first one, rent and utilities, it really shows it's everything unless it is specifically permitted. So rent and utilities. Second one, holding deposits, capped at 1 week's rent. Thirdly, oh, sorry, I've got those one way around. So holding deposits capped at a week. Tenancy deposits, the security deposit, capped at 5 weeks, unless the annual aggregate rent on the property is over £50,000. If it is over £50,000, the cap is 6 weeks. And finally, tenant default fees. Now, we've got slides on all of those three at the bottom coming up. So Tessa, I wonder whether it's a good idea now, just if anybody's got any questions or clarifications on what is and what isn't allowed.
Okay, I have just had one person say that she can't hear, so I am hoping very much that she's in a minority. So can you put your hand up, please, everybody, and just confirm that you can actually hear? Good, Stuart can hear. Yes, excellent, good. So I'll do a little reply to her saying that there might be something wrong with her machine. Sandra's asked a question saying, what about when bills are included and we have to charge for overusage?
So that's a very good question, Sandra, actually. So inclusive of bills is perfectly acceptable. And actually the Tenant Fees Act doesn't really relate to that sort of situation. So the Tenant Fees Act isn't going to change the law in this regard. However, there is a law, and Tessa, I can't quite remember off the top of my head what it's called. It's a law about you are not allowed to make a profit if you are recharging electricity on top of the rent or utilities on top of the rent, because otherwise you will become a utility provider and need to be regulated.
Oh, yeah, some local authorities got caught by that, didn't they?
Yes, I can't quite remember what the law is actually called. But it isn't actually affected. So what you're doing is perfectly lawful. It's perfectly acceptable. There are no changes as a result of the tenant fees ban to that. Just make sure you don't fall foul of that other law. And Tessa, I wonder at the end if you could just pop up what that law is, because I'm sorry, I can't quite remember what it is.
I can't remember what it is. I'm not sure I'm going to be able to do that because I'd have to do a search. But if you could email it over to me later, I can put it with the recording and give a link to it.
I know it is actually in the draft guidance notes to the tenant fees ban. So if you'll give me 1 second just to pull them up on my computer. There we go. So give me 1 second. Here we go. So it is the maximum resale price provisions set by Ofgem.
Okay, so I'll do a search for that and do a link with it and put it with the recordings. Yeah. With the recording when that goes online. Yeah. David, I've got a question. I appreciate it's to do with the third party payments, and you may be coming onto this later on, but if I had heard that there isn't a problem if it's a choice whether the tenant pays it or not. For example, things like tenants insurance, and there are guarantee companies where you can pay for a guarantee, stuff like that.
That's actually a really good question, Tessa. Yeah, and yes, you are absolutely right. There's a slide later on about the deposit replacement schemes. So if I take the deposit replacement schemes out for a second, and we'll come on to that in a moment. Okay. But the things like contents insurance, if it is an option, that will be acceptable. If you say you have to have tenants' contents insurance, the cost of that will either have to be borne by the landlord or it will be a prohibited payment. If you say you should, it's highly recommended, it will protect your possessions. The landlord's insurance only covers the landlord's possession. And, we would recommend you go to this this insurance company, that's fine as long as the tenant can say, no, I don't want it, and that's the end of it. Same with tenants' liability insurance. If you want the tenant to have tenants' liability insurance and you want to make it a condition of them having the property, then you have to cover the cost of it. If you say, we highly recommend you have tenants' contents insurance, but if they say no, it doesn't matter, then again, that will be fine as long as there is a choice. The one that causes